Hi everyone, I'm Salvatore Di Costanzo. I'm an elder law and estate planning attorney here in Westchester County with offices in Rye and Yorktown Heights, New York. And it's great to be here again to share some useful information with everybody. I hope everybody's doing well, and I hope everybody's enjoying this heat wave that we're experiencing now. We thought we would change it up a little bit and bring it outdoors. Probably the hottest day of the year to decide to do this, but we just thought it would be nice to change the scenery a little bit and enjoy the fresh air. So today we're going to be talking about strategies to obtain Medicaid eligibility. And I've lectured on this on several occasions, but I've been being asked the same questions on a more frequent basis as to how to render somebody eligible for Medicaid, whether at home or in a nursing home. And there's a lot of different ways that as elder law attorneys we work to achieve Medicaid eligibility for people. And the message here is that there's usually always a way to obtain Medicaid eligibility. And that's the message that I want you to take home today from this chat session. Just because you have assets doesn't mean that you're ineligible for Medicaid. I mean, from a statutory perspective, from a textbook perspective, yes, if you have over a certain amount of assets, you're not eligible for Medicaid. But as elder law attorneys, there's a whole host of planning techniques that we can implement that can move your assets around and render you eligible for Medicaid even when there are assets on the table. So I want you to be aware of that, and I don't want you to feel that all hope is lost if you've done no planning and God forbid somebody gets sick and needs care. So let's talk about some of the common techniques that we might implement, and these are some of the things that, some of the questions that have been being asked of me over the last few weeks. For instance, let's say there's a husband and wife. Let's start out with that. There's a husband and wife, and husband needs care, whether it's home care or nursing home care. We regularly use something called spousal refusal. A lot of people don't realize that there's something called spousal refusal, or if you've heard of spousal refusal, you're unaware of what it really is. So let's talk about what it is. Spousal refusal allows, in this particular case, the husband to transfer his assets to the wife. And the wife can refuse to use those assets towards the cost of the husband's care. That's called spousal refusal. And I know it sounds too good to be true, but it's one of our favorite planning techniques. If the husband, this is another reason why you hear me talking about the power of attorney very often. If the husband has lost his capacity, right, let's say it's dementia or Alzheimer's, we want to make sure that there's a good power of attorney in place to allow for the transfer of the assets, to allow for the gifting of the assets back to the wife. If there's no good power of attorney in place, then we are going to be forced to do a guardianship, and you've heard me talk about guardianships in the past. So spousal refusal is something that we use on a very common basis. It's very easy to implement. There are some repercussions. For instance, even though the Medicaid laws allow the husband to transfer his assets to the wife for Medicaid eligibility purposes, Medicaid could eventually come after the wife for what we call contribution. So the wife is going to sign a piece of paper that says she refuses to use her assets towards the husband's care. But under New York state law, she remains a legally responsible relative. So a husband and wife, you're legally responsible for the care of the other. So you can't throw that aside. You can't waive that, if you would. So what may happen, and I'm not saying it will happen, but what may happen, and it usually depends, sometimes it's the luck of the draw, sometimes it depends on the amount of assets that are on the table, but after we've implemented a spousal refusal plan, Medicaid, or should I say the Department of Social Services, they may send the spouse, the wife, a letter asking for her to contribute to the cost of her husband's care. And so we don't know when that's going to happen. It could happen. And if it does happen, I want you to remember one thing. If Medicaid sends a letter to the spouse, which we call the community spouse, the number that they're asking the community spouse to contribute is a lot lower than if she would have had to pay privately. So for instance, let's say her husband is in a nursing home. The nursing home may cost $15,000 a month. Medicaid doesn't pay the nursing home $15,000 a month. Medicaid, every nursing home has a different contractual rate. So this particular nursing home might be paying $10,000 a month on behalf of the husband. So when they send the letter to the spouse, it's not for $15,000 a month, it's for $10,000 a month. So a lot of people get nervous and they get anxious where they say, Sal, you made me implement this spousal refusal technique. You told me we were going to get Medicaid eligibility, but now I get a letter from Medicaid telling me that I got to write a check for X amount of dollars. Why did I hire you? The answer is simple. Number one, and the main reason why you hired us, is the amount that you need to pay Medicaid is far less than what you would have paid privately. And it can be significantly less depending on how long your loved one is in the nursing facility. Depending on the county, we might be able to negotiate the amount as well. It's becoming more difficult to do that, but we've been successful at times to negotiate certain amounts. And if we can't negotiate the dollar amount to a lower figure, we have been able to get the county to agree to not come after you again. Because sometimes what they do is they might send you the letter after, let's say, 6 months, but your loved one is still there in the nursing facility. So we've been able to negotiate with the county to say, listen, we'll pay you what you've asked us for, but that's it. It's for past and future care for my loved one. So there's a lot of benefits to doing spousal refusal. So spousal refusal is one of our major planning techniques. I'm going to take a sip of my lemonade over here to make it real. Now, one of the things that you need to do, and this is where the rubber hits the road, if you're going to implement spousal refusal and your husband's assets are transferred to you, and a lot of people miss this, what happens if you die first? If you die first and you don't have a will in place, or you have an old will, those assets are likely to pass back to your husband. And I've seen a lot of cases where the community spouse has died first. The stress, the anxiety, you might have underlying health issues. If you die first and you don't have proper planning in place, your assets are going to pass back to your husband, and he's in a nursing home, and now we're going to be in a situation where we're going to lose a lot of those assets. So the thing that you want to be able to do is redraft your will if you do spousal refusal. Redraft your will so that way it says, I don't want to leave anything to my husband if I die first. I want to leave everything directly to my kids. Or you want to leave everything someplace else. Now in New York State, you cannot fully disinherit a spouse. But that's a different issue for a different day. But you'll be able to protect most of your assets if you die first. So that's spousal refusal. In a situation where somebody is unmarried, let's say you're a widow or a widower, or perhaps you were never married, and you have assets, and you get sick, and you need nursing home care. Most people think that it's over. You didn't do any planning. There's a couple $100,000 in your brokerage account or your bank account plus your house. And because you've done no planning, you're going to lose all these assets. That's not true if you work with an elder law attorney. And that may sound like a big surprise to a lot of people. But I want you to hear that, and I want you to digest that. A good elder law attorney can always try to save you some assets. So in this particular case, where we have a single individual that might need care. Perhaps it's your spouse. Well, it's not your spouse because it's a single situation. Perhaps it's your parent or a grandparent. There's something called a promissory note gifting strategy. You may have heard of this. It's pretty sophisticated. But what it does is it results in saving about 45% of your assets. And it's a little bit too complicated to really go through in a session like this. But let's say there's $100,000 on the table, no planning in place, and the person is going into a nursing home. We can crunch some numbers, we can do some calculations where we can gift, let's say roughly 50 to 60% of those assets to a child. And then the remaining 40% is going to be loaned to the child. The initial gift creates a penalty. There are look-back periods, there are penalty periods that we've discussed in prior sessions, and maybe I'll talk a little bit about that now. And let's say it creates a 5-month penalty period. That means that your loved one is ineligible for Medicaid for 5 months because they gave money away to someone other than a spouse. During that 5-month period, the loan of the remaining assets is going to be used to pay the nursing home. When it's all over, the penalty period is done, the loan has been paid off, the nursing home has been paid, and we saved you the gifted amount. And so it's a very technical plan, if you would. It's very sophisticated, but we use this on a regular basis to try to save assets at the 11th hour. So the message that I want you to take home with that is there's always something that we can do as elder law attorneys, even at the 11th hour. I might not be able to save you a lot of money, but I can save you something. It might only be 40%, but I can save you 40%. Of course, the power of attorney is instrumental. We want to be able to move people's assets around if they've lost their capacity, and a good power of attorney allows us to do that. So we've got traditional spousal refusal in a husband and wife scenario. We've got promissory note gifting strategies where there is no spouse. And there's some other techniques that we can talk about as well, but I think there might be a question. Maybe we'll answer that question.
There is. Does Medicaid consider it fraudulent when the spouse signs the spousal refusal?
Medicaid does not consider it fraudulent. As a matter of fact, the spousal refusal rules are in the statute. It's statutory. So the social services law and the regulations and other things talk about spousal refusal. It's well settled. It's not, this is not a gray area. There's nothing that I'm telling you that is, maybe it will work, maybe it won't work. These have been time-tested planning techniques. As a matter of fact, just to kind of give you further support, the very fact that you remain a legally responsible relative under New York state law, is enough that should give you comfort, because they can come after you, like I discussed before. They can ask you for contribution. So when you do a spousal refusal, not only are you signing a piece of paper refusing to use your assets, but your spouse that's ill, in other words, the applicant is going to sign something called an assignment. And if he can't, the power of attorney will sign the assignment. And what he's doing is he's assigning his right to be supported by you under New York state law to the county. And that's why the county can come after you, right? They stand in his shoes. And that's why they can come after you later on for contribution, right? So I hope that answers your question. There are some very basic, let's talk about the look-back periods for a moment, right? Right now, and then I'm going to talk about some basic techniques to get around the look-back periods. Right now, there's a 5-year look-back period for nursing home care. It's been like that for quite a while. So if you transfer your assets today, or if you set up a trust, you hear me talking about trust all the time, there's a 5-year look-back period. You're not going to be eligible for Medicaid for 5 years. Right now, as we sit here and speak, for home care purposes, there's no look-back period. But the law was just recently changed. So beginning October 1st of this year, there's going to be a 2.5-year look-back period for home care purposes. And we have reason to believe that they're going to defer implementation of that until January, but it's something that we need to start talking about and we need to be aware of. Because right now, if you wanted to apply for home care, let's say somebody needed an aide to come into the house, we can move the assets right now to anybody that we want, and there's no look-back period. So home care has always been a very friendly, very favorable way of getting Medicaid eligibility. In fact, if somebody set up a trust and we were inside a 5-year look-back period, we'd often try to get home care to be put in place so that way we can get past the 5 years for nursing home care. So we'd have our loved ones stay at home, put care in place, get Medicaid to pay for it, and then get past the 5-year look-back period. That's going to be difficult now. So one of the messages that I want to give you is, if you have anybody in your family or you know anybody that's kind of on the brink of needing care at home, you should be contacting us, and we should be proceeding with haste to try to get Medicaid to be put in place over the next couple of months, so that way we can move the assets around and not be subject to the new 2.5-year look-back period. Now, I want to remind everybody, and this is very confusing because I didn't say it, the look-back periods do not apply to transfers between spouses. That's why spousal refusal is so great. Spousal refusal works with home care and nursing home care cases. There is no look-back period for transfers between spouses. The look-back only applies when you start transferring assets to someone other than a spouse. And I'm going to talk about some instances where it doesn't apply in non-spousal cases as well, but I want you to remember that. So this new look-back period for home care is going to be a problem. I think there's another question.
2 more. Is there currently a look-back period for assisted living facilities?
The answer is no. Assisted living does not take Medicaid. So Medicaid only covers nursing home and home care. There are a couple of facilities in the surrounding region that are assisted living facilities that do accept Medicaid. There's one down in Yonkers and there's one up in Carmel. But generally speaking, Medicaid does not pay for assisted living. If you were going to apply for Medicaid at, for instance, the place in Carmel's Clover Lake, I believe it is, it's treated as a home care case. And we don't know, I'm not at this point prepared to speak as to what the rules are going to be with the new look-back period. So it could impact that. I'm just not sure at this time. Another question?
Does a co-op with right of survivorship go to probate? And also, will Medicaid try to recoup money from the sale of co-op jointly owned if a nursing home or health care is involved?
So those are good questions. It's not necessarily on topic, but I'll answer them. Co-ops are very unique animals, if you will. They're not always that friendly to plan with. So often we're setting up trust to try to protect your house or your co-op. The problem that we run into with co-ops is that many co-op boards, and I've written articles about this, many co-op boards do not allow the co-op to be transferred to a trust. And the problem with that is that if you were going to apply for Medicaid, while your co-op may not be considered an available asset for eligibility purposes because your primary residence is an exempt asset, there's something that we do call the Statement of Intent to Return Home. A Statement of Intent to Return Home, where if you go into a nursing home, we'll have you sign a Statement of Intent to Return Home that keeps your primary residence as an exempt asset, I'm going to say for a while. Because the theory is that you're only going into the nursing home for rehabilitative purposes, and eventually you're going to come out of the nursing home and you want to go home. So we would do that with the co-op as well. The problem is that when you die, Medicaid has what we call an estate recovery, where they have a claim against your estate for any benefits that they've paid on your behalf. So ordinarily, we would take your house, or if it's a co-op where they allow transfers to trust, we would transfer your house, or we would transfer your trust, your co-op, to a trust. If you come to me well in advance, we set up the Medicaid Trust, which you're always hearing me lecture about. If it's at the last minute, we might set up a Revocable Trust to avoid probate, because the key here is Medicaid's estate recovery is only valid, it's only a viable claim against your probate estate. Assets that go through your probate estate are assets that you own in your individual name with no joint owner. So for instance, if I own my house and there's nobody else on the deed with me, my kids are going to have to probate my house when I die to sell it. If you own a co-op that's owned jointly with somebody, if it's owned as joint tenants with right to survivorship, that does not go through probate. That goes to the joint owner. But that may not be a good Medicaid planning technique, right? And to the extent you have an asset like a co-op that does go through probate, Medicaid's going to come in and they're going to come after that asset. Kind of like the Spousal Refusal claim. So that's a really big problem with co-ops. And if you have a co-op, you're going to want to talk to me about a Medicaid trust. So Medicaid does have the right to come after your estate. The challenge is to protect your assets even after you go on to Medicaid. So here's something that I see happening very often. And it happens often by non-elder law attorneys. So you might use a social worker or a geriatric care manager to do a Medicaid home care application. And they put all the pieces in place and they file the application and they get your husband on Medicaid. And everybody's happy. Maybe you save some money in legal fees because, you know, attorneys are so expensive. And everybody's happy. But nobody did anything about the house. So now when the person that's on Medicaid dies, and let's say there's no spouse, you have to probate the will of that person to sell the house. And when you do that, Medicaid comes in the back door and they say, hey, thank you very much. We've paid 2 years of home care services. When you sell that house, I want you to pay us. And you don't really have a choice. So there's planning to be done at all stages. Before you get sick, that's what I'm trying to get people to do. I'm trying to get people to call me to do planning in advance. There's planning that can be done at the time of sickness, which most people turn a blind eye to that. Because, number one, look, let's face it. You've got a loved one that just got a stroke, or a diagnosis of dementia or Alzheimer's. You're not thinking about planning, but you need to, right? We can do stuff for you even at the 11th hour. And then there's post-eligibility planning, such as setting up a revocable trust to protect a house. Or perhaps further planning for the community spouse, like I said before, with a last will and testament. Right? So there's so many things that we can do. That's what it means to work with an elder law attorney. That's what it means to hire an elder law attorney. Don't be myopic. Don't look at these things as the filing of a Medicaid application in and of itself. If you're somebody, and people call me up all the time and do this, if you're somebody that's shopping around for the best price on a Medicaid application, you're really selling yourself short. You might save money today, but it's going to cost you money in the long run, which I've just illustrated to you in this half-hour lecture that we just did. I can't do anything more than that. I can't come to your house and pull you out of your house and bring you into my office. But I strongly encourage you to work with an elder law attorney to implement some of these things. Are there any more questions, Drew?
Not at the
So,
moment.
I've been talking about the look-back period, and I've been talking about how it doesn't apply to transfers between spouses. There are some other instances where the look-back period doesn't apply. For instance, you might have a caretaker child. So a good elder law attorney, when we sit down, before we start going down the road of trust and other types of planning techniques, we want to try to decipher the entire fact pattern here. And if somebody comes to me and says that they have a caretaker child, meaning a child living with them at the house for the 2 years prior to the applicant entering a nursing home, I could take that house and transfer it to that caretaker child. That's an exempt transfer. Medicaid is not going to impose a penalty period. And so that's a really useful planning technique. That's another discussion for another day. Because there's a whole host of tax consequences, there's different ways of doing it. So I can't get into that today, but there's more to talk about. But caretaker child transfers are very, very popular. You also have an opportunity to transfer assets to disabled children, to trust for disabled individuals, like supplemental needs trust, right? So these are, again, topics for another day, but these are opportunities to avoid the look-back period. There's an exempt transfer that a lot of people never even think about, transfers to siblings with an equity interest in your house. So I see this often with some of my older Italian clients, where, grandma, this was my own family, grandma, grandpa, and my aunts all lived together in the same house. If my grandmother had owned a house, which she did not, they rented, she would have been able to transfer that house to her sister, who was living with her. She was a sibling with an equity interest in the house. So you can play hot potato. Only to a certain point, though, because eventually there's going to be the last man standing. So it does not negate the planning that we should be talking about in advance. So these are all different types of strategies to obtain Medicaid eligibility. A lot of them we can do in advance. Some of them we can do while the problem is arising. And some have to be done in conjunction with a Medicaid application and thereafter. And I hope that you found this to be useful. I hope you call me. We're fully functional, we're fully operational, back in the office, ready, willing, and able to help you. If you would like to go onto my website is planned today for tomorrow, all spelled out. You're free to call us at 914-925-1010. And if you like these, please share them with your friends. Our Facebook followers have increased substantially over this pandemic because we've been doing these a lot. We get a lot of great positive feedback, and I appreciate any support that you can give us. Enjoy your weekend, and we'll see you in a couple weeks. Take care.